everybody, and welcome to another episode of BHBA Family Law Presents Direct Examination with Dan and Lauren. Along with Lauren Youngman from Youngman Reitshtein, I'm Dan Bemel, financial advisor and certified divorce financial analyst. During each episode of our show, we explore our guests' personal and professional history and dig into meaningful legal topics. Please continue to join us for our upcoming episodes, always at 12:30 p.m., Christina Royce on January 12th, and Larry Ginsberg on February 2nd. The links are available in the chat box and on the bar's event calendar. We'll be announcing our next round of guests soon. Lauren.
Thanks, Dan. Good afternoon, everyone. You will receive your MCLE certificate shortly after the program. Please take a moment to complete the survey that's included with your certificate. The family law section is sponsored by White, Zuckerman, Warsofsky, Luna, and Hunt, and Our Family Wizard. White, Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Our Family Wizard is a secure co-parenting platform that supports divorced or separated parents in managing the daily responsibilities of raising children. Specialized features help co-parents organize routines, share files, track expenses and payments, check in at exchanges, send messages, and more, all while thoroughly documenting their activity. That's it from our sponsors. So Dan, we can go ahead and begin the program.
All right, thanks, Lauren. Today, we welcome Judge Elizabeth Scully. We're so excited to have Judge Scully here, not only to talk about what she's learned in her first year on the bench, but because she's one of the few people in our community with such a high proficiency and really such a great reputation as a litigator, a mediator, a professor, a speaker and educator, as minors counsel, and now as a judicial officer. That's a lot to get to, including a lot of tips she's picked up in each of those roles. But first, and most importantly, thank you for joining us today, Judge Scully.
Oh, thank you so much for having me. I'm really pleased to be included. You all suggested that I watch a couple of the others as part of preparation, and I did. And then I enjoyed them so much, I watched all of them, and it was really struck by the incredible breadth of experience and what wonderful resources family law attorneys can be for one another. So thank you for this really beautiful and interesting show. I'm very glad to be here.
Awesome. Well, thank you. And that's a great reminder to plug the YouTube channel. Thank you for watching all those. All of our former episodes are up on YouTube on the Beverly Hills Bar channel, where you can just search for BHBA Direct Examination and it'll come right up. So let's jump right in, Judge Scully. We want to talk first about going onto the bench. But first, let's just spend a couple minutes talking about going to law school and finding your way to family law. Was that always the plan? Was it kind of a natural fit from the beginning?
Yeah, I was really sort of an accidental tourist in law school. I had been a Latin or classics major undergrad, not a very pre-professional, practical choice. And, in the minds of my parents, and I guess sort of me, there were, only three possible careers. You could be a doctor, a lawyer, or a professor. I bet you all did not know that those were the only three available choices, but it seemed to some of us that that was it. The ship had sailed on doctor. I had never taken any science classes once I wasn't required to. And, I liked the classics work that I was doing, but really I wasn't sure that I loved it enough to devote my entire life to it. And my parents had both been in academia and strongly discouraged me from that. So that left law school, and my dad said I had to go, and I did not have a coherent, well-articulated plan B to fight for at all. and, wasn't really ready to graduate from college anyway. That was very painful for me to get, I got launched suddenly and voluntarily, and thought, well, I don't know, I guess it's flexible and it'll give me options, and I'm pretty good at school. How hard could it be? Right. A question that was answered to my dismay, a few months later, when I showed up. And I remember, the very beginning, I don't know if you all had this, but there's some case about people that are shipwrecked with only cans of turnips and a turtle that they fished out to eat, and maybe they kill one of the other shipwrecked people in order to ensure survival. And is that okay? And not having any clue what lawyers did, what law school was, just sitting in the class on the first day while everyone else is so sort of rapt and fascinated, and is that okay? Is that okay? And I was just sitting there going, no. And it's not, oh, this is going to be a very long 3 years. So I had no business being there, didn't know what I wanted to do, but the thread is that I've always been interested in children and children's issues. I had actually a Montessori school teacher that remained a friend of the family that had a home childcare center, and I used to go hang out with her there for years and help her with the kids. I worked at a preschool in summers when I was in college, and I knew that I loved kids. And so kind of here in law school, looking around, one of the only things that I could connect with, or that made me think there was any way of doing this work in a way that was meaningful or that I felt passionate about, was that kid connection. So as soon as I could take electives, I took a seminar on children and the law, which I loved. And that same professor taught family law. She had written a case book. And so I got into it that way. I always, it was integral to my conception of myself as an attorney from the very beginning, that it was going to have to be something having to do with family law.
So I want to fast forward before we go back. When did the bench start calling? When did you start thinking about becoming a judge?
Well, I had for quite some time. I would say maybe around maybe 2013 or 2014. And it wasn't something, it seemed very unattainable. It seemed like, maybe people that had always wanted to be lawyers, would be the people that would become judges, although I loved my career very much. But I knew that I came from a less traditional background. I hadn't been a DA, I hadn't been a PD, I didn't have a lot of jury trial experience. I did have teaching and mediation and some of the other things that we'll talk about in the course of our conversation. And I felt like because of that background, I had some things to offer that just in my own experience as someone using the court system might be helpful, and might be sort of importing the best of some of CDR or mediation ideas or teaching ideas into court to make it more user friendly. But I didn't think of it for myself. It was actually Judge Mitchell Beckloff, who I'm sure many of you remember from his days in family court and then in probate. He's in civil now. But he had been appointing me to represent children in guardianship cases after I started my own practice. And he had asked me to give sort of a brown bag workshop just on that kind of work and talking to children. And afterwards, he came up to me, and said, wow, the way that you're talking about this process, or the way that you're looking at things, or the way that you're thinking about neutrality or the perception of neutrality is very judge-like, very judicial, and you really should think about this. or words to that effect. And that was a very beautiful moment. It was the first time that the seed got planted, when someone that I had valued and respected so much had the idea that that might be something worth exploring. So I initially applied to be a court commissioner, right, which is another kind of judicial officer that is an employee of the court. And they have search committees through the court that interview people and come up with a list, a commissioner's list. And then historically, although I think there's no requirement, then they appoint commissioners in order off the list. I applied for that kind of as a way of putting my toe in the water, and also because the application was similar, and I thought it would help incentivize me to complete the application, which is really the judicial application and the commissioner applications are unbelievably extensive and time consuming and really require a lot of work. So I got an initial interview, but not a second one. Then I submitted an application, went through then Governor Brown, but at the very end of his tenure. And you're not supposed to submit a judicial application at the end. You're supposed to do it as soon as possible, because everything turns over from new. If there's a new governor, they can change the application. There's a whole new appointment secretary, a whole new process. So you submit it like, your message in the bottle that you throw into the ocean, and they never say, yes or no. You just, it times out, new governor. Okay, I guess nothing came of that. So then earlier in 2020, they reopened the commissioner search. And so I applied for that and then revamped my application and submitted that to Governor Newsom's office. So I was applying on that dual track for commissioner and judicial officer.
And once you received the appointment, what was that like, transitioning from private practice into the bench?
Oh, it's such a huge transition. It's such an identity shift. It was really hard to find words for. I was so excited. There was also a little bit of a loss because there was aspects of practice that I really loved, and was going into the unknown of something that I thought that I would really love and appreciate, but I didn't fully know what it entailed yet. But we found out in the middle of November, and then I had until or I closed my practice by the end of the year and then got sworn in, I think, December 30th. But I knew that my application was progressing and that I had interviews and I was moving forward. And so I did have it in the back of my mind. I stopped taking big litigation cases just in case. And I tried to get everything set up so that if I was fortunate enough to get that good news, that I would be able to transition everyone and really not have my clients feel abandoned or rushed, or as though I weren't, really tying up all the loose ends and wrapping it up and either completing the case or handing it over to a new person and facilitating the establishment of that new relationship.
So do you have any advice for practitioners that might be thinking about wanting to become a judge in the family law community?
Well, I'd say, again, that traditionally, not that many family law attorneys have applied. And I feel like there's a recent movement or a thought that, it might be nice to have people with a family law background in family law, right? Clients are always astonished that that's not the case. But I have to say, which is not to say that people cannot come in and be absolutely wonderful family law judges without that background. And I'm just in awe of, Judge Swift and Wilcox and Garrett and now Judge Neal and all of these people who, are coming into family law and just, able to hit the ground running. I think it was, believe me, challenging enough, even being oriented in terms of what the law is. But in terms of advice, I would say if you're serious about it and you want it, then don't give up. I did keep trying, and I tried many times, and that was some advice that I got that was meaningful to me. Some judges that I talked to, or that were interested, or being supportive, said, look, if you really want it, then it can happen for you, but you just have to not give up and keep trying. The other thing is that that the application is like this crazy scavenger hunt of your entire career. Basic every case of any import that you ever handled, who were the clients and who were the lawyers and where was it and what happened, and all of this, you have to have all this information. And basically everybody with whom you had any professional interaction at all, like forever, either gets directly called by the Jenny Commission, or by LA counties has its own kind of investigatory, not all counties do, but LA does, or Wright or Jenny. I mean, people get called from the beginning, middle, end of your careers. It could be other lawyers, it could be other colleagues, it could be clients, I suppose. It could self-represented litigants on the other side, or judicial officers. And so that the breadth of that is kind of tremendous. And I would say that just conducting yourself ethically, and in a friendly, appropriate, cooperative, non-nasty way as soon as possible, because if you do want to apply, then really there's no limit to the people that have come into contact with you that might be asked to give feedback and to say, I thought this person was appropriate and competent, or I thought this person was inappropriate or unethical or biased in some way. And so it's really this, which fortunately you all would be doing anyway. And there's many wonderful reasons to be cultivating a positive reputation in the community. But that was a little like, oh my gosh, they can ask. I hope I was nice enough, because they can ask everybody I've ever met for 15 years.
Did that feel intrusive? Were you expecting that? I mean, I'm sure somebody told you that was going to happen, but how did it feel going through it?
Well, you kind of know, but then you don't know. I mean,
Yeah.
of course, if you had said to me, is that going to be intrusive? Are you going to feel exposed? I would have said, gosh, I suppose I would have, but I didn't think about it. The turning point comes when your application has been forwarded to the Jenny Commission, the Judicial Nominee Evaluation Commission. That's when you have to put lists of all of the references. You have to give them, 50 to 75 names, in addition to any mammal that's identified anywhere on your entire application. And that's when all the questionnaires go out. And at that point, it stops being a what if, or maybe I'll try, or maybe I'll just go for it, so that, I won't have regrets later. And that then becomes a very public thing, which is, it is. You just have to hope that the investment that you made in relationships along the way, where, I won't say pays off. It's not exactly like that, but just, that you hope, you trust the ties that you have built, and your reputation in the community. And at that point, it's, it's beyond your control, and
You're
have
there,
to get comfortable with that. And sometimes lawyers aren't comfortable with things that are beyond our control.
So you've been on the bench for about a year. Big picture now, what do you think about the job, and how different is it than what you thought it was going to be going in?
Oh, wow. We had about a month of training. So when I went into Department 27 and actually started sitting in that department was the very beginning of February. So yeah, it's approaching a year. It's still very new, still figuring it all out. But I love it so much. I love it so much. I'm so excited to come every day. Every day there's something different. I don't know. I can't. I'm sure I'll think of bigger, better words to talk about it. But I've just been so happy. It worked out so beautifully for me. And again, I thought I would like it, or I wouldn't have applied. I certainly thought that I had something to offer that would be useful. I wanted to serve the public in that way. I wanted to bring my family law knowledge to bear, in an interesting way. Like all of that, I thought, but I didn't know that I would love it, or that, they send around these, questionnaires every once in a while about your future assignments and where might you want to be in the future. And all I could think of was just keep me here forever. I don't want to, I never want to go anywhere else. Just 27 for the next 20 years. And that's great. And I didn't know that going in.
Well, let me ask you, what specifically have you enjoyed about it? And I remember something you mentioned in our conversation last week was that you have your judicial happy place. Can you describe a little bit of what those things are?
Oh, I like all of it. I do like a lot just working with self-represented litigants. I love lawyers, obviously. I was one of you forever. You could take the girl out of the bar, but but I do like very much working with self-represented litigants. That was something that I did a lot as minors counsel. And where there's a parenting issue, and it's not so much that everyone's at each other's throats. It's just that they were told to file and get orders because they don't have any orders, and they don't know what kind of thing would be useful, or what how to approach it. That if I have the time to kind of have a discussion with them. And again, always being mindful that I'm not a mediator anymore and that my role is different, but conducting a hearing with self-represented people on parenting issues, you are going to have to do some information gathering. You are going to have to do some questioning about what interests and concerns people have, and see if you can come up with something that everyone winds up feeling good about, or at least willing to try, and then they leave with answers and certainty. And that's my favorite, when things seem there's a tension in the room and things seem a little messy. People are very fearful, and then they realize that that what their concerns are being heard, and that there's some structure here and a path, and maybe things are going to be a little more calm, and you see the hearing unfold in that way. I like that very much. But I also, a lot of the work is working up the calendars, which can take hours and hours and hours. And you're just jumping into pleadings, jumping into, oh my gosh, here's a story, here's an issue, and trying to get a sense of the family. I actually like that a lot. When I did minors counsel work that was appointed in guardianship cases, not to be a nerd, but it was a little bit like opening a present, that you get emailed the basic pleadings, and it was like this discovery. Okay, I'm just so curious, who are the kids, and who is this family, and what's going on here, and what can I figure out, and how can I help? So I do actually really enjoy the process of working up the calendars and reading pleadings and all of that. And I love working with the court staff, who are just amazing. I really lucked out in 27 and learning sort of the cast of characters in the court. And just like our collaborative cases, this here is an interdisciplinary team as well, where everyone plays a very vital role. I think my perception always as a lawyer was everything just started and ended with the judge, and everyone else is just kind of ancillary supporting the judge. But that's not really true at all. A lot of what I do is making sure that the other professionals can do their job. The interpreters, making sure that people are speaking slowly, that the interpreters can be heard, that the reporter can do his or her job, all of that. And so that's been really lovely to build relationships with the people in the court and understand that the public is only served when we are all working together to make sure that the others in that department and in that space are being their best selves professionally and able to do what they need to do.
So you brought up the calendar, and I want to go into that because that's so much of the day to day of what's going on in every department, and we hear from people from especially hurried lawyers that may say, well, why can't you just take the bench at 8:30 every morning? What's going on? So tell us what's going on back there if that's not happening.
So the calendar, it's like I don't know, in the play, in the drama that is the courtroom on the daily basis, a key character of the whole thing lurking in the background is the calendar, and just the concept of the calendar and all of the matters that the court needs to get through on that day. And I thought, okay, well, there must be a system, or they must know, or be able to predict how long everything's going to take. And, I don't know how hard could it be? But sometimes it is very difficult to predict how long something is going to take, especially in family law, right? Where nothing is ministerial, nothing is trivial. Something might be very ministerial from the court's point of view, that didn't require a lot of workup. It's, uncontested. It's a trial setting conference. But, sometimes that's the only contact that the case has with the judicial officer if they didn't come in for any temporary orders. And everyone wants to, tell you what's been going on and what the issues are. And so even things that seem like they should be short sometimes, take on a life of their own. And I really value attorney time, and I really value litigant time as well. Being mindful of the fact that people had to take days off from work for that court hearing. They may not have a job where there are that many available. It really is a matter of livelihoods in jeopardy if people have to keep coming back, or the cost and expense of transportation or childcare that people had to arrange in order to be there. So, for everyone else, and for myself, because if I don't finish the calendar, those cases go somewhere, right? We've got to get through the cases. But there's this constant balance between giving a case enough time so that people feel heard and people don't feel hustled. Because one thing in my short time on the bench, hearings go sideways. People get angry when they feel they're being rushed and they feel they're being hustled. And people just know when you're like, oh my God, TikTok, I have 20 other things. So, you have to just be very intentional and really think about how you handle those. I will be very transparent and say, listen, you can see what time it is. You can see all of the matters on calendar. I really appreciate your patience. I know you've been waiting. We're here to accomplish something very specific today. We're going to have the time to do that. I know there's a lot more to the story. You will have an opportunity to make me aware of all of it. It won't be today. And, you're going to hear me being very focused. It doesn't mean that I don't want to hear what you're saying, but we've really got to stay on track today, something like that. But I used to show up at 8:30 and be like, oh my God, I got up so early. Now I'm milling around in the hallway and the other person's there that I don't want to see. And I'm antsy. And this, I'm thinking about all of the things that I have to do. Like, what on earth are they doing back there? I promise we're working. Think about all the video appearances and the time it takes to check people in on those. And then some people are in person, but some people are on the video. Those people have to all be checked in. On the calendar, routinely, there are 2 or 3 or 4 or 6 things that don't go forward, either because a stipulation has been reached or there's an agreement to continue it. I know lawyers make an effort to communicate that to the court in advance. And, it's been challenging in COVID because you can't get directly through to the department. But a lot of the time, I just don't know. I have to work up everything as though it's going forward. And then so you figure out and you kind of have a sense of this is going to be the long thing, or I know I'm going to need to allocate time to this. But then, everything then gets shuffled around because some of the things that you had budgeted time for aren't going to be going forward. You also have to notice the interpreter matters because there's a limited number of interpreters who, by the way, are amazing. And what an incredible job that is. All of these, the court staff and the interpreters have these kinds of jobs where if they're doing it really beautifully, they're totally invisible. And so they kind of excellence themselves out of recognition or kudos. But anyway, when there's an interpreter matter, I'm going to have to take that because, other courtrooms are waiting for that person. So that affects it. So it takes time then to get all of that information from the check-in and figure out, are there things that can just be resolved right away off the record and we can, get that continuance going and nobody has to wait around. Of course, in the meantime, there are DVROs and ex partes also coming in that have to be addressed. But it takes a minute of strategic thinking and planning to figure out how the day's calendar is going to go. And so it may feel like everyone is waiting and you all can't see what's going on behind the scenes, but I promise you that the making the time for the strategic thinking and the plan of how to run the day is at the service of everybody getting their cases heard and getting out of there on the same day.
But not just a leisurely breakfast.
No, and I love breakfast. I would be happy to have a leisurely breakfast, but yeah, no, that's not what's going on back here.
So knowing that when it's finally our turn, we have a limited amount of time because the calendar is what it is. What sort of tips or practical advice do you have for family law practitioners for when they're advocating in front of you? What's the most important elements that you want counsel to focus on? And has any of that perception changed from when you were a practitioner versus now that you've been on the bench?
Gosh, I mean, part of it is just make sure that you've done what you need to do in order to get the orders that you want. I mean, I've said before, I'm here to make orders. It doesn't cost me extra to make an order. I'm happy to make an order if there's a legal basis for making the order. But, you've got to give me the evidence, and here's the legal standard, and this is what you have to satisfy in order to get here. So make sure you've got all the evidence to get there. A lot of time there's just little things, and I know that, it's hectic in practice, and, it seems like it was just yesterday that you were badgering the client for that updated income and expense declaration, but oh my gosh, somehow, 3 months has gone by. But there's a lot of times when, I would have made the order, but there's some essential piece missing, like an income and expense declaration, or if there's 1 or 2 lawyers involved in a case and there's a child support issue, you please run a guideline. Please bring a proposed guideline, because again, I know how to run guidelines. I'm happy to needle around in the guidelines in the abstract, but I can't if I have to get through everybody's case. That's not the best use of my time from a collective point of view. So I would say that, it's as basic as that. And then of course, there's an art, and lawyers will talk about, reading the judge or something. I don't think I'm very subtle. And if I really need to hear more about something, I will usually say, okay, I've heard about that, or I understand that. What I really want to hear now about is X. And a lot of times people will, say, yes, Your Honor, and then they go back to what they were talking about before. I think some of it has to do with preparation in the form of an outline, and you get a little bit wedded to how you wanted to have the conversation. And you need to be a little bit more improvisational than that as the attorney. Although frankly, I may be missing something. So it's fine to say, well, Your Honor, we've moved on, but there's an important aspect of that other thing that I just want to make sure. I mean, you can ask, you can make sure I may be missing something. That's just fine. But if I say I don't want to hear about this and I do want to hear about this, a good idea, selfishly from my point of view, right or wrong, I'd like to hear about what I'd like to hear about. And then just the meeting and conferring. And a lot of times I make orders to meet and confer and then come back and check in at the beginning and what's the status of the meet and confer, or as Judge Gordon always asks, when did you meet and confer? And a lot of people say, oh no, we didn't, or or they come and check in and the judicial assistant asks and they say no, they haven't done that. I mean, you're gonna get sent out to do that. And I mean something very specific by meet and confer. I don't mean, exchange positional emails confirming that everybody is tough and that nobody's willing to budge. But really a conversation like where you picked up the phone and you set aside time and you interacted with the other lawyer and you made an effort to understand the issue from their point of view. After a real meet and confer, I think Judge Gould-Saltman has explained it this way. Each person should be able to articulate what the other person's point of view is and why. And some of the things with these missing income and expense declarations are related too, because if there isn't a current income and expense declaration on file, then I know you cannot possibly have met and conferred about the child support issue, right? And I need people to do that because it's an adversarial system, right? I have lots of ideas about things that would work in a given case, but you need to take a position, right? I don't have some sorting hat up here saying Slytherin and 225. You need to tell me, and you all are going to be the ones, and your clients are going to be the ones that know the nuances of schedule and parameters and all of that. And again, I love having those conversations with people when I'm a mediator. But when I gotta just figure out what's going on and make rulings in an efficient way, I need that help, right? Because sometimes having an order is better than having no order, just because there's certainty and there isn't chaos. But my goal is not to make orders that are better than nothing because they're at least orders. I want to make orders that are tailored to the situation, that make sense for the child, that address the developmental needs of the child, that are workable for the parents, that are going to be complied with, all of those things.
So what about written advocacy? We spend a lot of time working up requests for orders, responsive declarations and replies, all of our briefs. What is it that in this past year of being on the bench, you have seen to be the most effective, or that you want to see more from counsel in your courtroom?
Mm-hmm. Well, I read everything, and I want everyone to know that my nightmare is being unprepared. So I will read what you provide. I guess, and sorry, there's a siren. I hope you can still hear me.
Yeah.
There's a lot of material that's in declarations that is argument, okay? And it's family law, we know that. There's a little whatever, but I guess I was shocked by that. You can't have it there, not just because it's improper, but from my point of view, I need things I can use, and I just can't use it. It's like, I don't know. Maybe I've been holiday shopping and nieces and nephews and thinking about Legos, but it's like you're in here saying, build me a pyramid, and, hand me a bunch of pieces. Like, you need to give me pieces that I can put together to make a pyramid. Don't give me things that don't add anything to what it is that I'm trying to construct, because I'm not just reading pleadings to let things flow over me to get a sense of what's going on, so that I can put on my sorting hat. I'm reading them with a very specific purpose. What is the evidence here? What is the information that I have that is relevant to this particular factor, or what I'm building? I'm trying to build something concrete. And so anything you give me that I can't use is, at best not helpful. But the problem is that it also, I think, creates a negative impression that people maybe aren't thinking about. If I see something with tons of argument, or, from a client, or tons of argument for an attorney, I don't think, oh, wow, the other person must really be bothering them. I think, wow, this is very angry. This parent is very, very angry. I wonder how that's carrying over into the co-parenting. I wonder, or, the declarations from lawyers that are like that, just really ratcheted up and accusatory. It doesn't make me think, gosh, the lawyer on the other side, really is behaving inappropriately. It just makes me think, oh boy, okay, so the lawyers are at each other's throats, and I see that that's part of this dynamic. And then the lawyers are modeling a kind of communication for the clients that is actually the opposite of what we're all trying to achieve, right? How can you tell clients, you're talkingparents.com, or you're Our Family Wizard, thank you for sponsoring Our Family Wizard, your co-parenting app communications need to be civil and brief and solution focused and child focused. And then as the lawyers submit letters that just show me the lawyers are behaving towards one another in a way that just doesn't match, the advice that the clients are getting. And we really have an opportunity as professionals, all of us, I do too, model for clients appropriate, constructive ways of communicating about conflict and listening to each other, and how to really listen, not just listen, getting ready to parry with, all of your wonderful points that you're going to make, model it. So I guess I like written pleadings that tell me clearly what the law is. If it's something obscure, you probably don't need to tell me about, 2030 or, something like that. But although I'll read it if you give it to me. But, if it's something off the beaten path, exactly what the law is, what the burden of proof is, but really stuff that's evidence that I can use to see if I can build what it is that you want me to build.
What's been the biggest challenge for you, other than obviously ineffective pleadings and counsel at each other's throats?
And I don't mean to sound negative either, because actually, as I said, I love the lawyers, and I really appreciate the contributions that you all make. And a lot of the pleadings that I get are just so excellent. So I'm not slamming lawyers. I'm responding to the question about what specific things work and what doesn't work.
Yeah,
but you mentioned challenges.
Yeah, no, and you mentioned, yeah, well, I'll pivot a little bit based on that, because you mentioned the culture too, and that's been one of the things that's come up on the show quite a bit, is the culture of civility that maybe has been kind of breaking down a little bit. It's something that we've talked about a lot. So from your seat, and I guess I was going to ask you about the challenges that you've had over the last year. And maybe that's part of it. And so maybe you can touch on both of those ideas a little bit, of what you've seen on that side.
On civility.
Yeah. If that's been one of the challenges, if seeing that's been one of the challenges.
I'm trying to think. I mean, certainly, I don't feel like during court hearings, I have generally an issue with attorneys just talking over each other or being disrespectful to one another during hearings or something like that. It's not something that's challenging to address if it happens. I think, and again, I don't see the lack of civility, except insofar as it's memorialized in letters, which then get attached and become part of a request for fees or a request for sanctions, or if it's something where someone is trying to make a point about their efforts to meet and confer and what they look like. Sometimes the interactions are pretty stunning, but I wasn't surprised because I was a family law attorney. But I just, when I taught, I would always try to ask students in the clinical class. We would do a lot of role plays, and they would either be consulting attorneys or mediators or something. And I would try to get them to say, okay, don't just talk. Don't just talk because you feel like you've been quiet for a while, or you want everyone to know that you're present and that you're paying attention. There's other ways of signaling to that. But when you speak, or from the mediator's point of view, when you intervene, you should have a strategic purpose. What is it that you're trying to accomplish? And then really think about, are those words that you're choosing the ones that are most likely to achieve the strategic purpose that you are trying to accomplish? And so sometimes when I see the correspondence that's not civil, that my question is, or I wonder, oh my gosh, everyone must be so miserable. You all must be so miserable. You're gonna burn out. Like, this really can't be working for anybody. And one of the beautiful things about this job is that I've been freed from the shackles of work email, pissy emails, the letters, where, you're kind of like, oh, what, do I really want to open the email? Or, you're traveling. I remember, just vacations for years and years when you're like, wait, is it after 5:30 in California? Okay, I'm not going to get anything else tonight, right? I mean, it's not a great way to live. Your cardiologist might have something to say about it, but so gosh, everyone must be so miserable. B, okay, this is clearly influencing this conflict, and what's the relationship between what's going on between the lawyers and what's going on with the clients. But more like, gosh, what could someone's strategic purpose possibly have been in writing this? Do you want the other person to understand that you're furious and that you've had it? Okay, I guess that would work. But is there something they're missing? Do you feel unheard by them? Do you think they're being unreasonable because of something about the law? Probably better, more tailored words you could choose to establish a purpose like that. And I think, just, going off, or like the have incivility being just, these letters, and that somehow everyone's expectation that you just have to put up with it. And if someone sends you one, then you have to respond in kind, I think is really a great shame. I think you're not achieving a strategic goal on the part of the client when you do that, which is really what we're doing when we're our best selves as lawyers. I lost my train of thought. I guess that's
No, I think that's
what I just said.
Yeah, no, it's good. These are so many. I think everybody really appreciates how many actual practical tips that you've been able to weave into all of your answers. That's definitely something we wanted to hear from you today. And I think with I can't believe we only have 10 minutes left, because we have to respect the calendar, of course. And so maybe we can turn the last 10 minutes into a little bit more of a lightning round, because I do want to roll back the clock a little bit and talk about some of the other hats you've worn during your career, and maybe stick with this idea of what we've been talking about all day, this new perspective from the bench and what attorneys should be doing in those other areas, maybe how your perspective has changed a little bit. So let's talk a little bit about mediation and ADR a little bit, and what you think attorneys should be doing in that area, both promoting mediation before litigation, how to set up a successful mediation. What would you be doing now? Let's go with that, and we'll try and hit the other ones too.
Well, and it dovetails, because there was, you talking about tips or suggestions, and I know in some of the other podcasts, there was this question of sort of how do you handle someone that's being very difficult or that's being very confrontational, or what should all family lawyers be doing vis-a-vis mediation and CDR and collaborative and all of that. And my number one pro tip is that I think every family law attorney, even if they don't plan to actually be a mediator, should take a 40-hour mediation course. And I know that is a big commitment, but here's the thing: the skills that you learn in a course like that, active listening and reframing and trying to understand the interests and concerns that are behind the positions that other people are taking, trying to respond to maybe the emotional content of what someone is saying, but pivot, to use your word, Dan, and so how do you reflect that back and say, gosh, you're so upset, but I wonder if what you're really concerned about is that I'm not getting that blah blah blah. How do you take that emotion and reframe and use it, redirect it into an interaction that is more constructive? Because guess what? That works with other lawyers. That works between lawyers and clients. That works between judges and litigants. It works between judges and advocates. These skills, I just can't overemphasize how useful they are. And one of the key things too, again, that I really tried to focus on with my mediation students, and you asked me about being a mediator, and I guess those are connected, because when I was teaching, I was really trying to distill the aspects of mediation that were most important to me. And one of my things was really about listening and the power of respectful listening. We would always start. Woody Mostyn is the one that originally taught the mediation clinical class at UCLA Law School. For a time, we taught it together, and then I sort of took it over and Lizified it and taught it myself. But the initial, and I'm grateful, for that opportunity, because I really did love teaching, and I used the teaching skills all the time on the bench too, explaining things to self-represented litigants and learning how to explain things in lay terms. But our first exercise always was to have the students pair off and interview one another, and then introduce the other person to the class, and then check in with the other person. Did I get that right? Was there anything that I missed? Or, give them an opportunity to sort of to correct it. And the pedagogical point, which is sort of the same one that I want to emphasize here, is that respectful listening in and of itself is trust building, and it changes the tenor of the room. You would ask the students, what did this feel like on the first day of class before and after that happened? And people would comment that, it suddenly felt like a community, or they felt like they had a friend, or it really felt good to hear someone say what they had said that was important about themselves. With that check-in, it makes people feel happy and good to be understood. And listening is super, super crucial. And so in terms of the mediation, in terms of that's a lot of what I'm trying to do on the bench. And it's not just listening to listen, but also listening in a way that communicates to the other person that you are hearing them and hearing them respectfully. And I think we talk about all of this, in civility or communication problems that trickle down from lawyers to clients. I think really working with intentionality on the skill of listening respectfully could really go a long way in making things better.
What about promoting or encouraging mediation for reluctant clients? There are a lot of clients who are out there looking for litigation counsel. They use terms like they want a shark or an aggressive attorney. How can we as practitioners encourage clients against this sort of approach?
Yeah, well, I think part of it has to do with this idea of informed consent. And before people ask for that, and what's their underlying interest and concern? They felt exploited or taken advantage of, and they don't want to have that happen anymore. They want to get separate from this relationship, but in a respectful way. They don't want to feel like they're, giving up or they're not advocating for themselves. They want to feel safe. They want to feel protected, right? So, so first of all, understanding what the meta communication is when people are asking for that. But I think a lot of people don't know what the panoply of options are. And again, it's litigators, all of us have an ethical obligation, I feel, to make sure that clients have informed consent about process options and what's available and what the pros and cons are. And you find, what's your goal? Is your goal confidentiality? You probably don't want to litigate. Is your goal getting a result as soon as possible or maximizing your own control over what that result looks like? You may think you want a litigation shark, but you may not if that path isn't the best way to realize the goals that the client has articulated. So, needing to have that conversation. But what I do, I will make orders trying to think about, again, I can't require people to mediate. That's beyond my jurisdiction unless it's, going to family court services or something like that. So I can't tell people that, but I will talk about it and I will say, I'm sure your lawyers have had this conversation with you. If not, they should. There are lots of options. And if you didn't like waiting around for 3 hours, that, you might want to think about some of these other options. And I also talk about the policy of the court to promote settlement in appropriate cases and talk to litigants myself about, I may be, completely well-intentioned and I'm going to be as prepared as possible. And I know the law, but you are the ones that know yourselves, your own family, your child. You don't have to leave it up to me. You have these choices. And I try to normalize mediation or settlement talks, because I think it's symbolically important coming from a judicial officer. People are fearful, they don't want to look weak. But if somebody in a robe says, this is not only okay, this is encouraged and expected and might really be the best thing for everybody, so you should think about it and try it. I'm hopeful that will get some people in the door. And sometimes the only tool that I have is my symbolic presence or what I represent, and things carry a different weight, not because it's Liz saying it, but because it's a judicial officer saying it. And so I try to use the fact that everyone's a captive audience, which is my favorite thing, to push people in that direction.
So for this captive audience, I think we're almost out of time. But I do have one last question and then we'll wrap it up. And I was thinking about this in terms of your role as a professor, which is one of the last ones I wanted to hit on, but also maybe more generally now from your new perspective on the bench. What are the most important things about the law generally that you tried to convey to your students, maybe now to younger attorneys? In other words, what do you wish you knew about the law when you first started that you want everybody to know who's starting out?
Okay, so reflections or things that might be useful for new lawyers or
Yeah.
for younger lawyers. Um, uh, I guess I guess a couple things come to mind. I mean, number one, I feel like there are a lot of lawyers that get burned out or that aren't able to sustain the work for years and years and years, and who leave to do other things, even though they might have been very gifted and very talented lawyers. And people often ask why I think that is. And I think one of the problems is an idea that I call congruence. When there is a lack of congruence between your personal values or what you think is important or how you interact with people in ordinary life and the work that you're doing or the professional persona that you've adopted for whatever reason or felt compelled to adopt. And, as I learned from this accidental tourist in law school, there are a lot of different ways to be a lawyer, and you can find what's important to you about it, what kind of impact you want to have, what you want your day to look like, what relationships you want to have with other colleagues. And this is flexible enough to where you can make those choices and make sure that there is that congruence, that you don't go into the office every morning and feel like you're a person that you hate, because you're not going to be able to sustain it. And it is a beautiful and satisfying career if you can find that. And I guess the other thing that I would say is to follow your instinct. For example, about clients. One of the things that happened to me in practice was when I was starting out, I thought, unless there was a really good reason not to take on a client that seemed sane and seemed like they could pay, I would be like, well, all right, I should take this, it seems like a good client. And I realized that in every single case that turned out to be problematic or where there was an issue, I had actually known it in the initial client interview. I had sensed it. I had a feeling it wasn't a fit. And for whatever reason, I had talked myself out of it. And so I made a change and, was in a position to do that. But honestly, it's not a question of, are you in a position in your practice to do that? You can't have problematic cases and clients. They will drag you down. They will impede your success. But just really listen to your own instinct about, is this someone that I can work with? Is this a case where I can make a positive difference? Or is there just something about the personalities or the situation that's raising your hackles a little bit? And honor your own reactions to that. My life got a lot better when I listened to my instincts instead of talking myself out of them in terms of client selection and that kind of thing.
I think we all could trust our instincts a little more and learn to say no a little more.
It's hard, right? But
Yeah.
we know, and sometimes boundary setting is hard, but it's absolutely crucial if you're going to have a successful life, and more importantly, a happy life in this career, in this community, with longevity and satisfaction.
Well, those are definitely words to live by and adopt in all of our practice. Thank you so much for being here with us today. I think we're a little over time, but it was well worth it. So thank you again. And everyone still listening, please do not forget to mark your calendars for our next episodes on all at 12:30. And January 12th, we have Christina Royce, Larry Ginsburg on February 2nd, and we'll be releasing our new guest list soon thereafter. Registration links are posted on the calendar and also in today's chat. We want to thank Genna and Belinda at the bar the Family Law Executive Committee, which is led by Gina Kang and Kendra Thomas, and of course our section sponsors. So thank you again to everyone. Happy holidays and Happy New Year. We'll see you in 2022.
Thank you.